These are appeals in the matter of Ryanair DAC and Lutz.
My Lord,
Mr. Brown.
my Lord, my Lady, Brown and Mr Welch for Storm, previously known as MCG. Mr Bowers, King's Counsel, and Mr Sheridan for Ryanair. For King's Counsel, Mr Crittenden, King's Counsel for Mr Lutz.
Yes.
The court has a core bundle, an authorities bundle, and a supplementary bundle.
We do.
There are some additional authorities that have been placed on the bench by Mr Lutz. And perhaps the home could be found for them in the authorities bundle.
Yes, we seem to have, we can put them in at our leisure. We seem to have one, in my case, I seem to have the same one twice. Statutory. That's well, they look, yes.
They look identical. I've got two of them too.
All right, that's fine. I just wonder whether my Lord or my Lady hadn't got one and I got two, but no. Okay, well, we'll throw one of them away.
My Lord, there should be Bauer in the IRLR and then the Advocate General in Daimler.
We've got the Advocate General in debt, but no, we have got. We haven't got anything called Bauer. We've got. Oh, Bauer is Statutory, yes. Okay, we got it twice. Is the only point I'm making.
Oh, sorry. My Lord, subject to the approval of the court, we've provided an indicative speaking time table.
Yes.
Pursuant to which I will speak first this morning, and then Mr Bowers and Mr Sheridan for Ryanair. And Mr Ford will begin this afternoon, carrying on until tomorrow, and then we'll reply tomorrow afternoon.
And I'm assuming that on the overlap points,
Yeah.
one of you has agreed to take primary responsibility. I'm assuming that probably Mr Bowers is taking responsibility on temporarily.
Yes, my Lord.
I guessed. Yep.
Yeah. There's one issue which I'm covering, which is the issue of the relevant contract to whom the supply is. And I'm proposing just to deal with all of my points in one go.
Yes, fine.
Even though that might mean that I'm straying into, but not trespassing upon, the
Sure will cope.
Mr Bowers is going to cover. And the court has had skeleton arguments, and I anticipate has read the judgments below and possibly a bit of the surrounding material.
Sorry, I just.
I anticipate that the court has read both of the judgments below, so the judgment.
We have read both of the judgments below, and we have read all the skeleton arguments.
My Lord, I'm grateful.
Speaking for myself, at least, I have certainly not read all the authorities.
No, and nor
Indeed,
I
most
think
of
anyone else due to. Certainly, the heart of our case is that the authorities that are relevant are very few in number, but I do propose to turn up some of the authorities that feature in Mr Lutz's skeleton argument, simply to explain and illustrate that they do not fundamentally alter the statements of the law in, for example, Uber, which is...
For example, Uber.
I'll come on to that in due course.
Yes, I have to find out what it was really about, but still.
Yeah. My Lord, employment status then is at the heart of the first issue, and before I open up the law, if I can make some introductory observations in relation to that first issue, as we have emphasised, the issue is not who was Mr Lutz employed by, the issue is was Mr Lutz employed by MCG, and I'll use MCG as a convenient label for my client.
Yes, well, don't worry, I'm not going to do that thing of jumping in and demanding submissions out of order, but can I flag up that although, of course, intellectually you are right, it's a bit difficult for us to answer the question whether they're employed by MCG without considering by whom else they might be employed.
Yes.
And there is a strong hint in your skeleton argument, to put it no higher, that the answer is that that either they're employed by nobody or they are employed by Ryanair. When I say employed, I mean obviously employed for the purpose of the regs.
Indeed.
Or they're employed by Ryanair. And if this is meant to be a test case so far as possible, and if the logic of your submissions, or indeed your actual submission, is that they're not employed by you but they are employed by Ryanair, we ought to consider whether that's the case.
Well, my Lord,
Ryanair are here and can say what they think about it.
Indeed, my Lord will approach the issues as the court sees fit. From the perspective of my client,
Yes.
I'm entitled to say, and do say, that what Mr Lutz needs to establish is an employment relationship in the relevant sense with MCG. And I agree, of course, that it might be, and probably is, a useful analytical tool to consider what the alternatives are. And they may indeed be no employment in the relevant sense, employment by Ryanair or something else. However, I am entitled to focus on the specific point that concerns my client, which is whether the factual findings support the conclusion that there is a relevant employment relationship with MCG.
Okay, well, we understand what
Yeah.
that. I see how you put it.
First point. Second point is, one has to, of course, recognise that there are specific features of this arrangement which are not necessarily the same as in all employment agency or employment relationships generally. And the point I am making here is that not all agencies operate in the same way. Employment agencies will sit on a spectrum. There is a range from, for example, full employment with conventional contracts of employment. Plenty of agencies operate that model. Indeed, my client operates that model in part, not in the context of this case, but as a matter of reality, agencies can employ individuals under employment contracts. Agencies can also, at the other end of the spectrum, provide, for example, basic ancillary services such as payroll and administrative management. Why that matters is that we say, contrary to Mr Lutz's submission, that there is no presumption.
So basic ancillary services, payroll management.
Yes,
Yeah.
An example might be payroll management, other ancillary services such as some basic management of a pool of agency workers. So they are not all the same. There has to be a contextualization process. One has to look at the facts in the specific context in question. And there is certainly no presumption in EU law or domestic law as to what the facts are in this sort of tripartite arrangement. And we say there is no presumption that either the employment agency or the hirer, or indeed anyone, will necessarily engage the worker in the relevant sense. So one has to look at the specific facts of the arrangement in question. So essentially in this appeal, there are two exercises. The first is to understand what the legal framework is, and then secondly, apply that realistically and sensibly to the facts without striving for a particular outcome either way. Ground one, we say that the tribunal was wrong.
Sorry, you were still running through your preliminary points.
Yeah.
So the first one is, the issue is it employed by MCG?
Yeah.
Second is not all agencies operate in the same way, so no presumptions.
Yeah.
And this is your third one, therefore.
And
Or not.
well, the third, perhaps this is obvious, but we say that the approach then is to analyse the legal framework and then apply that realistically and sensibly to the facts.
Oh, I see. I just thought that was some part of two. But anyway, it doesn't matter.
Yes,
I just want
no.
to get the structure right. Yep.
With that, then ground one. So I am now on ground one.
Okay.
The tribunal was wrong to conclude that the claimant was a crew member employed by MCG. It might be helpful just to look, please, at the relevant definition in the legislation. So authorities, is the court using tabs or electronic versions or a combination of?
I am using hard copy and therefore tabs.
It's tab 4.
The authorities bundles have not been very helpfully marked because we don't know which.
I'm assuming bundle 1.
Well, they don't have 1, 2, 3 on the back, or if they do, I can't see it.
I convey an apology on behalf of.
Don't worry, just give me a moment to do it. Someone just sing out, what are the tabs in each one?
The first bundle is tabs 1 to 24. The second bundle, tab 25 to 39.
Well, actually, no. My second bundle starts with tab 24. Sorry, time spent doing this now will save time.
Yeah. So is it 1 to 23, 24 to 39, and then everything else thereafter? 40 to
40 to 56.
50.
Okay, thank you. Don't know whether whoever put the bundles together is in court, but they will now see why these things matter. Right, okay, thank you. So we're in tab...
Bundle 1, tab 4, please. The Civil Aviation Working Time Regulations 2004. And please, can the court turn to page 19, Regulation 3, Interpretation. Does the court have that?
Yep.
Then one will see about 8 entries down, crew member, alphabetically arranged. That provides crew member means a person employed to act as a member of the cabin crew or flight crew on board a civil aircraft by an undertaking established in the United Kingdom. So obviously a pilot is a member of flight crew on board a civil aircraft. No one disputes that Mr Lutz is part of the flight crew. The focus is on the word employed and employed by. And this is common ground that this means employed in the autonomous EU sense. You have, of course, Section 230 of the Employment Rights Act 1996 behind tab 1. No need to look at that now in terms of the ordinary division between types of employment, which will be familiar to the court.
Sorry, all right, but I mean the Employment Rights Act as such has nothing to do with the case.
No, that's absolutely right. So in terms of the ordinary divisions between different types of employment, they will be familiar. They find statutory expression, of course,
Yes.
to a large extent in Section 230. My Lord is right, Section 230 has nothing to do with the case, and that's relevant for a point which I'll make in a moment by reference to the authority of James in Greenwich. But what I do want to show you before that, please, is a provision of the Working Time Regulations of 1998, so the general Working Time Regulations as opposed to the specific regulations applicable here. They're behind tab 2. And what you have, please, at page 11 is Regulation 36, which falls within Part 5 of the Working Time Regulations, special classes of person. Does the court have that?
Yeah.
And that refers to agency workers, not otherwise workers. This regulation applies in any case where the individual, the agency worker, is supplied to do work for another. A. B. Is not a worker because of the absence of a worker's contract between the individual and the agent or the principal, not otherwise in a party to a contract to do work as a part of a professional business undertaking. Now, to paraphrase, what Regulation 36 is doing is extending scope to agency workers, because the general difficulty, not an inevitable difficulty, but a general difficulty, is that there will not be a sufficient relationship between the worker and the agency so as to establish worker contract status for the purpose of protective rights. And Regulation 36 therefore contemplates that there will be situations where there is no relevant worker contract, and it extends the protective scope of the Working Time Regulations to agency workers in that category.
Hang on 1 second.
Yep. So one has a situation in a, let's say, paradigm agency worker situation. The individual could be an employee. They could have a contract of employment. They could have a work
With whom?
with the agency. It's a conceptual possibility that there is an employment contract between agency and individual. That could be express, could have been agreed. That happens. So it's
Yes,
out there
no,
now.
certainly. Yeah.
They could have a worker contract, express or implied. They could have no contract. Regulation 36 extends scope to them in circumstances where they have none.
Yeah.
There is no equivalent of Regulation 36 in the Civil Aviation Working Time Regulations. That is important because it goes to the various policy points that feature prominently in Mr Lutz's argument. It may be the case that this is an area that requires statutory control, if so desired. But as matters stand, there has not been any.
I think one of the provisions in the WTR was added later, but this isn't it. This has been there from the start, is that right?
I will...
Somewhere in the skeletons I noticed
Yeah.
a point about there having been an amendment to the working time regulations, or perhaps I'm misremembering, but
I'll check that before I answer that, if I may.
yes. Maybe I'm thinking of the agency.
I-
I'm thinking of the agency workers regulations. Yes, I see. So 36 has been there from the start.
Now, I said I wanted to deal with one point, which...
Could I just ask one thing? You needn't answer it now. If we were to look at the working time directive, on which the working time regulations is, from which it derives or which it implements, would we find a provision, not necessarily in this language, which this reflects?
Well, there'd obviously have to be a treaty basis for it.
Well, not necessarily.
Well, it's made by regulation, so it must be either in the directive or in the treaty. So, unless there is some other enabling power in some other primary legislation.
No, you could just do it under the European Communities Act.
One could, but...
Under under the bit that says you power to implement, but also
But it has to
make
have-
ancillary provisions, which this would count as.
Yes, but it would have to have the European law basis for it, though, which is why I referred to the treaty.
Well, so I'm wondering, I was questioning whether that was the case. What do you mean by European law basis?
If it goes further in conferring protection than European law, then you don't need a basis in the treaty, do you?
No, if it goes further than European law, then one needs to have another primary legislation treaty
Yes,
basis.
but the European Communities Act allows you to, if it's all old stuff now, we're gradually forgetting it, but 2.2 or whatever it was, that was 2.2a, which was power to make regulations to implement community obligations.
Yes, absolutely.
And I think it was 2.2b,
Yeah.
in addition, to do things in, as it were, in the same area as the implementation, but to add some bells and whistles. And this could be a bell and whistle.
Again, it is slightly painful, but my submission would be that the power of the European Communities Act has always been to implement provisions of European law as set out in the treaty and directives. Insofar as the legislator wishes to go further, then there'd be a primary...
Well, that's just what I'm not agreeing
For example,
with.
the Employment Relations Act 99 establishes the basis for extending treaty regulations beyond the directive, but it needs to have a primary act of parliament to do that.
Yes, but 2.2b is normal. Well, let's not argue about that.
Okay.
I think I'm right, but whether I am or not doesn't really matter. I want to know is whether there's something in the directive.
Yeah, no, I understand the question, and apologies that I would, again, just need to check so I answer precisely where the agency...
Mr. Ford knows the answer.
Oh, excellent.
Yeah, there's nothing.
Right.
The directive just applies to worker.
Thank you. Well, in that case, if you were right, Mr. Brown, this would be ultra vires. But
Well, no, I don't... Well, this debate is interesting, but why would it be ultra vires? Because the point my Lord has just pointed to me is that it wouldn't be, because...
yes, I know, but you were disagreeing with my point.
Oh, I see. Well, no, it wouldn't necessarily be ultra vires, because it depends on what the other... One can look at what the bases are, because they're always stated at the start of the regulation.
Yes, you've very economically not given us the start, so we don't know. But
No, that's right.
well, look, let's not spend time on this now. Could someone just
I
look
get it.
at the bevy of juniors? Someone can look this point up, or indeed leaders who are not speaking. I'm sure Mr Ford is right. There's nothing in the directive, so it just stresses what are the vires behind Regulation 36.
Yes, it certainly doesn't help Mr Lutz's argument either way, because the point is, we'd say that it is sufficiently clear that Regulation 36...
Yeah, you keep talking, Mr Brown. Mr Ford can get up in a minute.
Regulation 36 is necessary to address the potential mischief, if there is such a mischief, of agency workers not being in scope by reason of the absence of work.
I see your point. I just want to understand everything about this.
No, I understand.
Mr Ford, you're...
The vires is the ECA, my lord, no other.
So it's 22B or nothing, if I remember. Yeah.
22B or nothing. You may recall in Harper Trust, which you were involved in the earlier stage, there the Supreme Court said the provision there went further than the directive, but that was permissible.
Because
They didn't deal with the vires argument, but it was permissible.
No, I remember. And it's come up in one or two other cases, employment.
Yeah.
It's come up in lots of cases, but
It's come up in
employment cases.
It came up in Nolan,
Yes, it did.
and it came up in Oakley.
Yes.
So those are the...
Yeah, okay. Well, let's not spend any more time on this. Thank you. But anyway, your point about 36 is an obvious, but I can see from your point of view, important one, that 36 shows that there is a potential lacuna, and that the Secretary of State, the legislator, decided to deal with it in 1990 in the main working time regulations, but for good reason or bad, decided not to in
The civil aviation working time
Yeah.
regulations. Yep, that's our point. Can I deal with James and Greenwich? It features 3 times in Mr Lutz's skeleton arguments, paragraph 16, 26 and 53. Skeleton argument is behind tab 6. Perhaps if I could just open that up by reference to page 106 of the bundle.
Oh, sorry. What? You're going to James, but before you're going to James, you're showing us the bits.
Yeah, to understand the point that Mr Lutz made, this persuaded the Employment Appeals Tribunal, and I want to just set out our stall as to why this is not a correct analysis.
Okay. So 106 in the
In the core bundle, so it's Mr Lutz's first skeleton argument behind tab 6.
Sorry, just one other housekeeping point. Yes, this is the replacement skeleton argument. Some of the other skeleton arguments, I think, are not in replacement form.
I apologise, we filed a replacement.
I think Mr Bowers isn't. It may have been sent loose, but I haven't got it. Yeah.
We'll make sure we provide.
Thank you. Right. Okay, 106.
Yeah, so paragraph 26. We just go through it. First sentence, starting point is a surprising consequence of MCG's construction of the Civil Aviation Working Time Regulations, the AWR. The logic of MCG submission, although not spelled out, is that an agency worker will never be employed by the agency for the purposes of the CAWTR, nor for the purposes of the aviation agreement. Just interjecting, that's not our argument. It is perfectly possible for an agency worker to be employed by an agency.
Yes, but maybe he slightly overstated it, but the difficult case is where he isn't employed by the agency.
Indeed. So, difficult case. Then just passing the paragraph, and then I'll make my point by reference to James, because it is a point of some importance. The next sentence, this is because the essence of a triangular agency relationship is that the agency worker is assigned to work under the directional control of the hirer. I would agree with that, so far as it goes, that is a paradigmatic triangular agency relationship description. Then, next sentence, on MCG's analysis, the individual cannot be a worker of the agency because he does not work for it and is subject to the hirer's direction and control. And broadly speaking, we would agree that if the worker does not work for the agency because, for example, there is no direction and control, then they are unlikely to be a worker. And then the point with which we disagree in terms of the actual legal argument is the following one. They say, nor will the agency worker be a worker for the hire of the purposes of the CAWTR because he has no contract with it and it is not necessary to imply one. See James above. Now, the difficulty with that is that the autonomous concept of an EU worker relationship does not require any contract. Everybody accepts that. But the reason why it's wrong by reference to James and Greenwich is that James and Greenwich was concerned with an entirely different situation, which is that of employment status as an employee for the purpose of unfair dismissal rights. So see, please, Authorities, tab 26.
Hang on 1 second. Yes, sorry, yeah.
James and Greenwich, Authorities, tab 26, which is then bundle 2. And of course, in James and Greenwich, then, the issue is unfair dismissal protection. And that requires establishment of a contract of employment by reference to section 230, section 1. And the reason why those claims ultimately then fail is because on application of the common law principles of implication, it's not necessary to imply a contract of employment, which is necessary in order to establish unfair dismissal rights. So see, please, how Lord Justice Mummery puts it at paragraph 5, 4 and 4. So, of course, the correct legal question is not whether the claimant was an agency worker, whether working for an employment agency or an end user under an employment agency agreement, whether the claimant was employed by the respondent end user under contract for employment. The two types of contract, agency agreement and contract for employment, are not necessarily mutually exclusive. It's legally possible for a worker to have one kind of contract with an employment agency and another kind of contract with the end user to whom he renders services. This is an exercise of legal classification. It requires a fact-finding tribunal to examine and assess carefully, etc., etc. And to that extent, there's a parallel with the process involved here, that there may be more than one contract or legal relationship. Indeed, it's perfectly likely that there is. One has to appropriately categorise and classify what those contracts are. But the crux of the matter is at paragraphs 41 to 42, which is on page 422.
422.
Yes, 422, please. Paragraphs 41 and 42.
Shall we read the sideline paras?
Thank you.
Yeah.
And a point then that Mr Lutz made before the EAT, in which we say the EAT erred in accepting, is to say that the absence of a contract used perhaps in a loose sense, but the absence of a contract between Mr Lutz and Ryanair means that that's the end of the inquiry, and therefore one has to look towards MCG, what we would say is the gist of the tribunal's analysis and the EAT's analysis. The basis for that submission, which is Mr Lutz's argument by reference to James and Greenwich, is unsound because one does not need there to be a common law contract of any sort in the field with which we are concerned. Section 230, as my Lord Vice President put to me at the very beginning, is of no relevance as such. And one can be confident that that is correct because in Uber itself, there was also no contract in the sense of a written contract between the drivers and the entity with whom the employment rights were asserted, which was Uber London. But there was an employment relationship.
I suppose you would say that James is of limited assistance for two reasons. One being the one you've given, which is that it's concerned with common law principles.
Yeah.
And the other is that anyway, the finding is only that the tribunal was not perverse in holding them as unnecessary, which means that maybe another tribunal might have gone the other way.
Indeed. Absolutely right. It's difficult to conceive of situations where there would be such an implied employment contract in this triangle arrangement now, but it's possible. So I agree with the way my Lord puts it. It's not been ruled out, and indeed in this area it's very dangerous to make statements as to what the inevitable consequence will be of certain typical employment patterns, because it requires a particular factual analysis. I want to turn next to Uber, please.
Just note in passing, and when we get to the temporary worker point, an interesting comment in paragraph 44.
Yeah. Yes. I'm sure Mr Bowers is noting that then. If I may, I'll turn to Uber. Tab 47, please, which is under 3. Before I make submissions on the critical aspects of Lord Leggett's judgment, if I can just make good the point I made a moment ago about no written contract. That appears at paragraph 45, which is page 902, and 52, paragraph on page 904.
1 second. 45 and...
45 and 52.
Hang on 1 second, yes.
So no written contract with Uber London, against whom the employment rights are being asserted. Then principal analysis is from paragraph 71 and 72.
Hang on a sec, just 1 second. Yes, where are we going now, sorry?
Paragraph 71 and 72, please.
'71 and 72, did you say?
Yes.
Again, would you like us to read them?
Yes, certainly 72, please.
Right.
And 71.
Okay. 71, thank you.
Yes.
Mr Ford quite understandably asked the court to bear in mind paragraph 71 and the heading, the purpose of protecting workers. And of course, that is part of the exercise of statutory interpretation with which we are concerned. It is plainly no part of our case that this is anything other than protective legislation. That is priced into our submissions, but the question is the extent of that legislation and whether it applies in the particular situation in question, because it is, of course, the position of my clients that they're entitled to arrange their legal affairs by reference to the law as it stands and a proper and authentic interpretation of the law. And they know it is protective, but that nevertheless does not provide a panacea in all sorts of atypical employment status cases. The critical focus, we say, is on paragraph 72, and what one can take from paragraph 72 is essentially two general themes which are revealed by the European case law, to a large extent the domestic case law, which will indicate the existence of a worker contract. And first appears at between B and C, by reference to Allen B, which we'll look at. It must be considered as a worker, a person who, for a certain period of time, performs services for and under the direction of another person, in return for which he receives remuneration. And then a couple of lines down from that, the court added, paragraph 68, the authors of the treaty clearly did not intend the term worker should include independent providers of services who are not in a relationship of subordination with the person who receives the services. So, without wanting to over-paraphrase, the watchwords are essentially direction, otherwise known as control, and subordination.
So it's the factual nature of the relationship, but perhaps not the legal nature of the relationship.
My lady, the fact.
Sorry, I said, so maybe the factual nature of the relationship,
Yeah.
not necessarily the legal
Yeah,
nature of that
absolutely. And the relevance of the legal obligations, this is familiar to the court, is that, broadly speaking, where there are contractual arrangements, people act in accordance with them, and that then tells you what the economic reality is. However, that is not inevitably the case, and as Lord Legate tells us, one needs to be extremely careful in this context with starting with any form of presumption that parties will act in accordance with their contractual position, because certainly in the context of this form of work, they don't always. So one sees that paragraph 83, but before I show you 83, if I could just show you, please, paragraph 75, Lord Legate's judgment, refers to, it's in this way, the quality of the subordination and or dependency of employees and workers in a similar...
Sorry, where are you reading from?
75, please, on page 677.
Let me just read the whole paragraph.
Of course, thank you.
Yeah.
So note then, essentially the same definition then across the various protective statutes. Then paragraph 83, and if the court is to reserve, then I can invite you perhaps in due course to read all the way through to paragraph 83, but rather than doing all that now, if I can just focus on paragraph 83. makes the point I made a moment ago, that the contracts are not the appropriate starting point. Doesn't mean, of course, that they're irrelevant. They may be the strongest available evidence of how the parties are.
Yes, I'm surprised he goes so far as to say it's not the appropriate starting point. I can well understand why he should have said it's not the end.
No.
So you normally start with it. I mean, that's what he said.
Yes, that's what he said. One might have sympathy with that, because my submission a moment ago is that people generally do act in accordance with their contract.
Yes, quite.
However, it matters not, because one has to look at everything in the round. Certainly, one has to, though, exercise a degree of caution in response to one of Mr Lutz's further points, where he says, not by reference to findings of the tribunal, but he seeks to rely upon provisions of the contract which haven't been the subject of analysis by the tribunal in order to bolster the argument that MCG is employer. We say that's dangerous territory when there were no relevant findings that support that. But I'll park that for the time being. I'm just focusing on Uber. The actual conclusions are analysed from paragraph 94 of the judgment. Now, of course, this is a set of conclusions by reference to the facts of the individual case, and one will exercise caution in terms of any read across, but it is interesting to note the extent of the control which was sufficient to found the existence of the relevant relationship in Uber, as summarised from paragraphs 94, and to compare and contrast just for the purpose of an exercise with the tribunal's findings in this case. So one does see extensive control by Uber over the drivers in terms of the terms, where they travel, etc. And insofar as that was resolved in favour of the workers in Uber, we say that that really illustrates that that's the nature of the obligations that are likely to characterise a relevant employment relationship, and we are some way short of that in relation to MCG. But we'll look at the tribunal's findings on their own terms. Well, is there then some special rule that applies in the context of tripartite agency relationships? And the answer to that is no. Now, Mr Lutz relies on Allenby.
Just before we go to Allenby,
Yeah.
you may well be right, but Uber gives you all you need on the absence of a need for a written contract, or indeed even a contract.
Yeah.
It's not just, your position is not just that there doesn't have to be a written contract, there doesn't have to be a contract at all, as long as there's a relationship.
Yeah.
There are a number of cases that are about precisely that,
Yeah.
including the Supreme Court, Gillam, about judges, two or three others, I can't remember what they are, perhaps that's the only one in the Supreme Court, two or three others at the level of this court. I think Deliveroo was one of the points in Deliveroo, wasn't it? Are we going to be referred to those, or you just don't think they're necessary? Uber gives you all you need.
It gives me all I need. I understood it to be common ground that one doesn't.
It probably is, but I'm just wanting to see how they fit in. But those fit in. Okay, let's just take Gillam. Gillam fits into your analysis for that reason.
Yes, it does.
It was cited in Uber.
Yes, I'm wrong to say it's common ground, because it is clear from 26 and 53 of Mr Lutz's skeleton argument that his position is there has to be a contract, even in relation to the employment, the autonomous employment status. So it says, well, I'll let Mr Ford make this point.
Okay, so not common ground. You'll have to see exactly how it's put. But what I was just getting at with you was the well-known cases about
Yeah.
whether or not you need a contract are subsumed into Uber, effectively.
Yes, for this purpose. Perhaps unsurprisingly, Supreme Court, sitting as a 7, giving judgment as a 6, does a survey of the whole field and tells you what we would say is effectively everything one needs for these purposes.
Yeah. Okay, fine, thank you. You're going on to Allenby.
Yeah. Allenby, of course, cited in the passage in Uber to which I've taken the court, is a tab 22, which is in bundle 1. And if I can ask you to look at the court, please, and pick it up, please, at page 304, bottom right, paragraph 62.
Did you say tab 21?
Tab 22.
Oh, 22. Yes, thank you. Yes.
So under the heading, the concept of worker within the meaning of Article 141.
Sorry, which page did you
It's
say?
304.
304. Thank you. Yes.
So 62 through to 72.
This is an equal pay case.
Yeah. And the sidelined passage essentially states the principles which we say are faithfully reflected in Uber, as one would expect.
But you're not asked just to go through them, you're asked just to note them.
For 62, look please at 72, the conclusion. In the case of teachers who are vis-a-vis an intermediary undertaking, under an obligation to undertake an assignment at a college, it is necessary in particular to consider the extent of any limitation on their freedom to choose their timetable and the place and content of their work. The fact that no obligation is imposed on them to accept an assignment is of no consequence in that context.
Yes, are you going to tell us the facts in Allenby?
Yes, so supplied through an agency.
They were all people who had previously been on the staff at the college, weren't they?
Yeah, that's right.
And they basically dismissed them all,
Yeah.
and they were invited to reapply for
Same positions through the agency.
the same work, let's say, through an agency.
Yes. And then it says there's a pension issue and there's an Article 141 equal pay issue. And for our purposes, though, what matters is the fairly limited discussion of employment status, which is in the passages that I've shown you. But what the CJU does not do is to do anything other than remit this for some factual findings by the court in the usual way. And certainly there is no assumption or still less any conclusion, nor could there be, that as a matter of European Union law, if you're supplied by an agency to work for a hirer, your relevant employment relationship is with the agency, because it will completely depend on the facts in issue. There will be some cases when that's true and some cases where that's not true. So the existence of the tripartite structure does plainly present a difficulty, because there is then potentially the absence of the crucial controlling factors, i.e. control, etc. But LMB does not supply some alternative solution that you simply, we would say, foist the obligations on the agency, or putting it another way, you look through the person who is actually controlling or potentially controlling the worker, and impose the obligations on another legal person. There is no authority for that in Allenby at all, and simply asserting social policy protective legislation does not.
So he was actually controlling the worker, but neither in Allenby nor in MCG nor in your case are you actually controlling the worker.
We say that the facts do not support that. Of course, there is some interaction with the worker, but it's not of a sufficient level to amount to sufficient control.
I may have misunderstood what you were saying.
Well, my lord, all we're saying is that in Allenby, it's perfectly possible that there's a conclusion that the agencies are the relevant employer for Article 141 purposes. I don't actually know what the finding was of the fact-finding court when it was remitted. That's possible. It's equally possible that there is no such employment relationship. So, Mr Lutz's argument states the matter too firmly, because he asserts that the inevitable classification in a tripart situation has to be this out or the other. It has to be that the employment relationship is with the hirer, whereas we say that's not sufficiently nuanced, because one has to actually look at the individual facts and see whether the test is satisfied.
Do you mean the hirer?
No, the agency.
Oh, sorry, I mistake. I meant the agency.
Yep.
Now, in response, there's a very wide-ranging tour of the EU authorities in Mr Lutz's skeleton argument from paragraph 31, which appears at page 107 of the core bundle.
Yeah.
And our overarching submission is that, of course, we don't disagree with what the Court of Justice has said in a number of cases, but cases which have simply emphasised the importance of social policy are not likely to be particularly illuminating in this specific situation, because we accept that this is protective legislation. So, Stringer and Pfeiffer, it is of course important to do all of these things. Paragraph 32, there's reference to two other cases, so Del Cero, which is at tab 24.
Sorry, just one moment. Which page of the bundle are we on?
We're on core bundle, tab 6, page 107. Yeah. So there's a number of cases. I'm not going to turn up all of them because it wouldn't be proportionate, but in terms of the response, so paragraph 31 refers to the fact that health and safety is a fundamental social right and therefore wide reach. So by reference to Stringer and Pfeiffer.
Which paragraph are you on now?
It's paragraph 31 of...
Oh, I see. I thought you'd already addressed us on that.
Sorry, the paragraph 32 is about fixed-time worker discrimination. It's described as a closely related context. Well, again, we don't disagree with that, but it's not telling you very much about the specific question of employment status here. So fixed-time worker discrimination is what it is, but it's a very indirect point, if anything. Then paragraph 33, insofar as the implication of paragraph 33 is that there is some yet wider approach for employment status than that set out in Uber, we would say that is not correct. There is a single test, and that is Uber. And the cases that are cited, so Union Syndicale, tab 38, about French holiday camp seasonal workers, the fact that they're in scope, protection is simply manifestation of the law and its particular facts. And the same applies for Fennel, which is at tab 35. That's the person employed at a disability rehabilitation centre. They might be a worker. Again, not surprising. And then the fact that there needs to be consistent principles of interpretation across the relevant aspects of European law, which is Proposition 1 Williams, again, we would agree with all of that. Then 34 and 35, by reference to a case called FNV, makes a point which is a fair point, that the broad division is between self-employed and employed. We accept that broad classification, but it still is the case that Mr Lutz needs to prove a worker contract with MCG on its own terms.
But am I right in thinking, if the these are two quite distinct questions. An agency could supply, in the sense of introduce, a genuinely self-employed worker.
Yeah.
Or a genuinely self-employed worker could contract directly with the hirer.
Yes.
Now that the Ditchforth port complication has disappeared, as I gather it has at this level, just remind me, what is your analysis of the relationship between MCG and Mr Lutz? That he's a LIMB worker for you?
No, we say no relevant employment relationship.
For any purposes?
For any purposes. Discounting irrelevant ones such as whistleblowing, for example, where there's yet further complications. For these purposes. In paragraph 36 of the skeleton argument, and again, just want to focus on this for a moment. It says, fifth, in the context of triangular agency relationships, EU legislation presupposes that there is or can be an employment relationship with the agency. And we absolutely accept that there can be, not that there is. This is a critical point.
So I see this is 36. Yeah.
Yes.
Yep.
And it therefore follows that we disagree with how it's put in the final sentence above paragraph 37, where it says, on MCG's argument, such individuals cannot be workers or in an employment relationship with the agency as a matter of EU law, because MCG say they're not subject to the agency's direction and not working for it. Well, they can if they are subject to the agency's direction and working for it, but that depends whether they are.
Yep.
The 37 suggests that it's inconsistent with Allenby, but then respectfully say Allenby doesn't unlock any different analysis. All this paragraph records is certain factual findings which might point to a particular conclusion on the facts of Allenby. And it might be that Mr Lutz is right to say that the Court of Justice has given a bit of a steer to the fact-finding tribunal. Maybe it has, maybe it hasn't. But that all depends on the facts of the case. I'll come on to why the EAT erred in relation to the analysis of Allenby, because the EAT seems to have interpreted our argument as being that as essentially that, we say that it is conceptually inconceivable for there to be an employment relationship, and that's never been the case. We just say there isn't one here. So even if this paragraph is sufficiently anchored in the facts of Allenby, and I say that with some trepidation because the facts are fundamentally not before the Court of Justice other than in a very general way, it doesn't actually refer to any different analysis. And then
once Allenby came back from Luxembourg, was there any further reported litigation?
I'm not aware of any. No. And paragraph 38, there's a reference to a case called Rawland Clinic. So tab 38 might be helpful very briefly just to have a look at this one. That's volume 2.
So you asked us to get the case out?
Please, yeah.
Tab 42.
Tab 38.
Tab 38. Which bundle is that?
2. And the court's judgment is at, begins at, the relevant part is at page 704 from paragraph 25 under the heading the concept of worker. Does the court have that? So 27.
Yes.
27. The court
Okay, can we just have the factual basis here?
Yes, so this is agency workers. Let me remind myself. Perhaps easy just for the court to take it from the helpful IRLR head notice one usually sees, which is at 695. So facts there summarised in the top left. So it is a form of assignment.
Yes.
And one point, which of course will be critical, is that have to bear in mind that these sorts of secondment type agency relationships do vary quite significantly between different member states. And the conventional employment agency model, which is very prominent in the UK, is not typically the model that appears elsewhere. And therefore one does need to look at the specific nature of what is there described as the secondment arrangement. And the court's judgment...
I mean, the very language of secondment is the
Yeah.
language we'd use for an agency.
Yeah. But our short point really is if one reads the way that the court analyses it from paragraph 25 through to 38, it just says exactly the same as all the other cases. You need to look at the particular arrangement and see whether it meets the relevant minimum obligations that have been recognised in community case law. So it's an interesting example, but it's not determinative of the case against me.
Well, it's rather a long passage. Is there one paragraph which summarises what supports what you've just said?
Well, it's really 28 through to 38, and it's it's not necessary for the court to read all of that now. If the court is willing just to make a note, my submission is that essentially records the the general tenor of the community case law as to what a worker is, and there is no special rule that applies insofar as that is being hinted at or suggested in the context of a tripartite arrangement.
Paragraph 27 rather emphasises the point about there not needing to be a contract.
Yeah, that's right, my lady.
Yes, I need to do 28. Yes, all right. We won't read it all.
That's all the relevant law from the parties' skeleton arguments. No doubt there'll be further points, but broadly speaking, those are the cases. In terms then of the tribunal, factual findings, they appear in Core Bundle tab 18. Make my submissions on the findings, but we say broadly speaking, the touchstones identified in Uber are performing service for and under the direction of another person, the relationship of subordination, are not present on these factual findings or are not sufficiently present. Now, the reasons appear then from 267. The court might have seen that the EAT made some critical observations about the structure of this judgment, and they are well founded. There are structural difficulties. I'm not proposing to repeat any of that. What I propose to do is simply identify in order the relevant passages which we say are the factual findings, or at least appear to have been intended as such. Now, let's start with paragraph 1, what the case is about. So, we see paragraph 2, in summary, Ryanair has employed pilots. It also has a pool of contracted pilots who are not employees, so that's what we're concerned with. Ryanair has arranged that the second respondent, MCG, manages this pool of pilots. Ryanair sends people to MCG, which then directs these people to accountants who set them up. MCG organised everything for these pilots. And we'll see what the tribunal meant by that in a moment.
I'm not sure how important it is, but just as background, the footnote 2 suggests that although MCG supplied pilots primarily to Ryanair, it didn't supply them only to Ryanair.
Yeah.
That's correct, is it?
That is.
So it's not like Angard.
No.
Right.
In paragraph 3, the pilots were all treated identically, they say by Ryanair, and only a small difference in airside ID passes can distinguish them. Then, going forward, please, to paragraph 10. Paragraph 10, please, page 5 of the decision 270 in the bundle. Mr Lutz was the first officer on Ryanair's Boeing 737s. He had to pass Ryanair competency assessments. He had a Ryanair uniform. He's rostered by Ryanair. No one could possibly think he was other than part of a crew of the planes he flew. Planes would not fly without him being there. 11, so the first two issues must be resolved in favour of the claimant. You can leave that for the time being. In paragraph 12, Mr Lutz was employed in the operations of Ryanair, and the tribunal correctly identified that the word is wider than a contract of employment. But he does say, 3 lines up, he's certainly employed as a resource by Ryanair. Then says he had a contract with MCG. That his work was not under a contract of employment with them or anyone else does not change that fact. that is right, but we would say the relevant factual finding is reference to the employment as a resource by Ryanair. Then paragraph 15, he was flying planes, an integral part of the crew of the planes he flew, and the other crew members, so the stewards, etc., generally being Ryanair employees.
Where does he say that?
Well, we're only concerned with pilots, so my Lord's right. There's no other specific finding there regarding the other crew members, but that is factually the position.
Well, I don't think you should tell us that if it's
Why
not
not?
part of the findings. I'm sure it's right, or you wouldn't tell us, but more to the point, it's really irrelevant anyway, isn't it?
I'll move on. Then, of course, my point about whether one needs to be shown, i.e. not a worker for MCG, and I don't need to go further. And the tribunal makes the point which my Lord has made, well, might be helpful if there is further analysis beyond that. It's fine. But we say an important finding is that the integral member of the crew of the planes that he flew, and that's also reflected in paragraph 16. So 60, was he an agency worker for MCG? The first question is whether it's supplied by MCG. Then there's the own account, says patently not so. It says Ryanair had no dealings at all with the service company, that's Dishwood. MCG had almost no communication with Mr Lutz after he started flying for Ryanair before being dismissed. We say that is a very strong contra-indicator of there being any control as between MCG and Mr Lutz. The fact that there is no communication with him at all over many years.
Well, I suppose because he didn't get pay slips as such because of the Ditchforth complication, but presumably he got some sort of monthly statement, or Ditchforth got some sort of monthly statement from MCG saying you flew so many hours, and here's what you're due, and the money will be in your account next week. Is that how it works?
Absolutely, yeah. So when I started off with my spectrum, the ancillary services, we don't need to be detained about whether this was purely payroll, that's not an issue. But in terms of placing this on the relevant part of the spectrum, true it is there is communication in relation to remuneration, because there has to be. But one has to then stand back and say, well, is that character?
I understand that. I just want to get this factually right. Obviously, I assumed it was right, and it was. But
yeah,
it's not right to say no. What he means is no communication about operational matters.
Yes, communication.
The rosters don't come via MCG; they come straight from Ryanair.
Yeah. No communication that an experienced employment judge might expect to see in an employment relationship. So that does not feature. There is a communication about a no-show. So it's not nil returns in terms of communication, because there is a point, and it's dealt with later on in the judgment. Mr Lutz doesn't attend for a flight, and there's an email that's sent to him. And ultimately, the termination letter comes from MCG.
Because again, I don't know whether these documents were there, but conceptually what happened was Ryanair, whatever they may have said to him informally, who knows, but the formal bit is dealt with by Ryanair writing to MCG and saying, Mr Lutz, who you supply to us, didn't turn up.
Yeah.
What are you going to do about it?
Yeah. And the communication is sent. And then paragraph 18 makes the point about shift patterns. So this is 5 lines down. When Mr Lutz asked to change shifts, Ryanair...
18 is directed to a different issue, but you're just interested in the findings of fact.
Yes, and it's consistent with the later finding of fact anyway. That
okay, which are the findings of fact you're...
Ryanair decided about the changing of shift patterns.
Where do I find
It's
that?
a penultimate line and final line of 18 on
Yes, I see.
271.
Okay.
Then paragraph 20, second sentence, every aspect of Mr Lutz's engagement with Ryanair was structured as Ryanair dictated. Mr Lutz had no say in anything, he just did what he was told. Then evidence in the hearing, facts found at the top of page 8. In 27, there's findings relevant to other issues in the case. If I can ask the court, though, to read about 10 lines down, which begins that this has some relevance to the assessment of the arrangement at its start. By the time Mr Lutz came on board, the rostering was of all pilots employed and contracted on the same...
Sorry,
yeah.
where are you reading from?
Paragraph 27.
Yes, but whereabouts?
It's
Sentence beginning.
however, by the time Mr Lutz...
Yes, I see, thank you.
That sentence, please. Ryanair rosters the whole pool.
Can you help on this? That is a finding that factually all pilots were employed and contracted on the same basis, which doesn't by itself mean very much, but read against the previous sentences, it means there was no longer a series of temporary assignments with gaps in between.
Yeah.
Now, if Mr Lutz had been employed in the early days, you would have had a situation where, not asking for evidence about this, but just painting a general picture, in the slack seasons when there weren't so many flights, he would probably not be called on, unless somebody suddenly was ill or unexpectedly unavailable. So they would, all the year round, use their contracted pilots, use their employed pilots, and only use their contracted pilots in the busy periods. As between them and MCG, was there any obligation to use their contracted pilots for a minimum number of flying hours?
As between Ryanair and MCG?
Yes.
Yeah.
Because we know there was between MCG and Mr Lutz, he was promised at least 450, which is broadly speaking half the maximum that a pilot can fly.
Yes.
Have I got that right?
I don't know the answer in terms of the specific question about Ryanair and MCG. I'll check that.
It would be odd, because it would expose MCG if they had made a contractual obligation to Mr Lutz that he should have at least 450 flying hours, which they do. I can give you the reference, but I'm sure you know it. If they didn't have an equivalent promise from Ryanair, because they find themselves having to pay some sort of compensation, presumably, for not supplying that amount of work. I would therefore quite like to know.
Yeah.
Again, probably this doesn't go to any of the legal issues, but you don't know till you've actually worked it out. But what I'm getting to is this, off the back of the passage you've just taken us to, there isn't actually a finding, or is there, that during the currency of his work for Ryanair, he actually worked something like, he worked as many flying hours as an employed pilot.
No, there is not that specific finding.
Do we know? Is there any evidence about this?
Well, the difficulty with this, and especially the difficulty with the court's question, is that it's fundamentally for the tribunal to decide what's relevant, including by reference to the contractual obligations. So I would respectfully say that it is potentially a dangerous exercise to start looking back at things like the contracts, given what Lord Leggett has told us, if in fact it's this which the tribunal has decided is relevant to characterising the employment relationship.
Well, since I wasn't looking at the contract, I was looking at the evidence about whether... I'm just looking at what it means by saying the rostering was of all pilots employed and contracted on the same basis. If that meant that all that contracted and employed pilots viewed as a whole got the same number of flying hours,
yes,
that would be one thing. But it doesn't say that, but that may be what it's meant to mean.
Well, that's certainly, others can say they disagree, broadly consistent with my impression of the evidence as it was given, is that they would be rostered in the same way.
I don't know what in the same way means.
I'm
just trying, because one of his complaints, I think, about not having employed status, there are various complaints, but one is that you haven't got the same certainty of getting as many flying hours as you want.
Yes.
And which slightly implies that under the way it was working during the years he worked there, contracted pilots didn't get as many hours as employed pilots. Otherwise, what's his underlying complaint?
Well, his legal complaint was just a complaint, because he certainly did have a general employment complaint, i.e. a grievance type complaint about rostering.
But rostering can be about different things. It can be I'm rostered to fly this kind of flight rather than that kind of flight, or I'm rostered to fly on Thursdays and it suits me better to fly on Tuesdays. I mean, I don't know what rostering complaints were.
Broadly speaking, the evidence was that they had a fixed shift pattern, which was 4 days on, 3 days off, on a continuous cycle. Was it 4 and 3? Yes. Yeah. So it would keep on rolling, but there was an option then to work additional days within that. So effectively, you could put your hand up for additional shifts, and he wanted to do that, and he wasn't being allocated what he wanted, but he had the broad...
Was that because the employed pilots got first pick?
I don't recall there being any evidence to that effect.
Okay, well, if there wasn't any evidence, strictly you might say I can't go beyond the findings, but I think we can all go beyond the findings a bit if the evidence was clear. But you're saying you just don't, the evidence wasn't, as you recall it, wasn't clear either.
Not to that level of fine detail, because broadly speaking, what the tribunal did mean by rostering is that they were all on the same, what was described as a Ryanair shift pattern, which is well known within the industry as 4 days on, 3 days, keeps on rolling. You could work on those off days, because of course there would be absences and standby and things like that.
So the only reason why he would get less flying hours than an employed pilot would be either if he didn't choose to put his hands up, when an employed pilot did, or he did put his hands up, but they gave preference to employed pilots, which would be perfectly possible, and in a sense would reflect the different status between the two.
Yes.
But the answer, we don't know about that.
Yeah, no evidence.
Okay, well, fine. I don't want to take it further than the evidence goes. So,
well, forgive me for standing up again, but there is a finding at the end of paragraph 74. I don't know if you can see that, my lord.
End of paragraph
74.
74. Okay, well, I obviously didn't put that up.
It doesn't quite answer my lord's point.
Oh, well.
But it does say the rostering's the same, and said contracted pilots have variable earnings as they guaranteed 450 may work.
Well, yes.
But then says,
Well, that you can work out from you can work out from the contract.
but he does go on to say, while roster is the same for both, there is plainly the risk for contracted pilots. The possibility
Yes, I see. So the implication of that is, as long as rostering is the same for both, that's not a problem. The risk is that it doesn't have to be the same for both.
Yes.
Okay. Well, look, I really don't want to spend too much time on this. I just want to get a feel for what it was meant by saying that they were rostered on the same basis and what the implications of that were, which you have helpfully given me.
If I may, though, just respond to my Lord's point about the extent to which we can go beyond findings. I do emphasise that is an exercise which is potentially fraught with difficulty because, for example, an assumption that the contract is a safe description of how the parties actually interacted is wrong. I mean, one has to actually look at the contract as perceived and as operated.
Of course.
So broadly speaking, we are constrained by what we have here. And that is it.
Okay, thank you.
So 29, so advertised, for 28 and 29, MCG didn't procure anyone to be a pilot, Ryanair advertised for pilots, and they were sent to MCG to process. And Ryanair advertised for the pilots, and he applied to Ryanair. And he was assessed then Ryanair 32, he was directed to be a contracted pilot, so directed by Ryanair to
By MCG.
he was directed to be a contracted pilot, no,
By Michael Lowe.
right, 28. In reality, MCG did not procure anyone to be a pilot. Ryanair advertised pilots and put them through a preliminary assessment, and then those they were approved were sent to MCG to process. So I say that the correct reading of that is that the finding is that Ryanair made the decision and then sent them to MCG for the purposes of the contracting which then follows. So insofar as it says he was directed to be a contracted pilot, 32 should be read with 28, and that is directed by Ryanair. And then Michael Lodewick of MCG emailed him to tell him so. Then the email from Mr Lodewick: successfully passed the interview, been offered the position as a cadet on the cadet programme, qualified as a contracted pilot, operating for our client Ryanair, begin the aviation of the chosen contractor for cadets coming through the CA programme.
Should we understand that his first contact with MCG, and indeed perhaps the first time he's even heard of them, is when Mr Lodewick emails him to say that he's passed?
Yes, my lord. Then, unsurprisingly, he is trained to Ryanair's specifications. So the description is described at 36 and 37. He's told which aircraft he's going to be trained on. And in fact, he pays for his own training, but then because of his status, he's entitled to offset that against tax. Then MCG come back in, so paragraph 39. They say he needs to set up an Irish limited company. He's provided with the details. And that is what it is. So those arrangements then are in place. Paragraph 43. Mr Lutz, having applied to Ryanair and been told that he was successful, was told he's to be engaged with another company, MCG, by that company, not by Ryanair, and he'd have to set up an Irish...
So where are you reading from now?
Paragraph 43, please.
Yeah.
44, there is no action taken by Mr Lutz that was not directed by Ryanair and all were non-negotiable. He wanted to be employed by Ryanair, that's what he'd applied for. Throughout his time as contractor pilot with Ryanair, he pressed Ryanair to become an employed pilot. So 46, couldn't take unpaid work, he wanted to be an employed Ryanair pilot. Then, and 5 lines up in 46, he was exclusively a Ryanair pilot. For reasons set out in his judgment, he's not a self-employed individual, nor was he trained through a service company. He was a pilot placed by MCG with Ryanair. That was how Ryanair set it up. Then some findings about the intermediary companies and the substitution clause, but we don't need to be detained by those. So there's some initial onboarding documentation, it's not described as that, but that's the FAQs, for example, at 57, things like that. Then 61, the reality is that Mr Lutz was simply a pilot whose skills Ryanair utilised as an individual otherwise than as an employee. Then there's the letter about the missed shift. So this is the other communication as between my client and Mr Lutz. So after all of the onboarding and the initial setup processes, then it's the email which is set out in full at 61 about the missed shift. And then that's it until the termination, essentially.
You haven't taken us to the contract, but you're going to, are you?
No, I'm not, my lord. I'm doing all of this by reference to the tribunal's findings. Because that's the approach.
So the tribunal made findings about the contract.
Yeah. So
you talked about onboarding.
which contract, my lord?
Sorry?
I might have misunderstood the question. Were you asking if I'm going to take you to the original document or to the tribunal's findings? No, I'm not proposing to take you to the contract.
Okay.
Then there's a point about MCG's interactions with the government department, paragraph 63, and about whether there was a fully informed opt-out. We don't need to be concerned about any of that, they're no longer relevant. Then the findings pick up again from paragraph 73. So at the outset, MCG informed Mr Lutz of the based at Stansted, but then as the following findings make clear, this was a Ryanair decision. In paragraph 74, the shift patterns were rostered in detail for 4 weeks ahead and in outline 8 weeks ahead, so regular shifts. Pilots expected to work those shifts. If they wanted to change a shift, they had to find someone to swap with. And they used the Q.Doc intranet system. And they would then be swapping with the ordinary Ryanair pilots. And then the point that Mr Ford has taken you to. I won't repeat that at the end of paragraph 74. And 75, there was one aspect in which MCG was involved, which was when Mr Lutz was asked to do all early shifts and the colleague to do all late shifts. This was communicated to Mr Lutz via MCG after he'd made the request to the rostering team. The approval is entirely personal. So this, as is clear from the findings which we look at, is that Ryanair then roster and they authorise or otherwise the decision to request earlies. Then there's points which perhaps are more relevant to the temporary permanent question. But it is important to note at paragraph 82 that in respect of all of that, there is a finding that this is all part of a system put in place by Ryanair, meant that Mr Lutz's work life was run by agents of Ryanair. And 84 deals with some of the remuneration, the pay bargaining and collective bargaining arrangements. Just picking up 5 lines now. MCG was implementing Ryanair's way of dealing with non-employed pilots. It was Balper which negotiated with Ryanair. His host, Smith, as an MCG person, had regular meetings with Ryanair, and he told her that Ryanair had decided to treat contractor pilots as employed pilots. So essentially, when the collective bargaining decisions are reached with Balper, they then get communicated through MCG because that's relevant to payment processing. And 85 records the termination event.
Yep.
Then there's additional factors at paragraph 90. I'll come back to the Uber in a moment. The finding which appears elsewhere that he's wearing a Ryanair uniform, flying a Ryanair plane filled with Ryanair passengers. And then 104. There's a further a list of findings.
These are all going to a different issue, but
Well, they're consistent with findings which.
Yes, no, fine. But these are all ones we've seen already.
Exactly. They helpfully appear in paragraph 104.
Yep.
And what is notable is the extent to which MCG does not feature. It's there, of course, but all of the findings which one might put in the mix as being indicative of the touchstones of employment are findings made by reference to Ryanair, not by reference to MCG. And Mr Lutz will say, well, there's enough. True it is, there might be a rather overwhelming emphasis of factors which are not relevant to MCG, but there is nevertheless enough. We say, well, plainly isn't. And it's not an answer to say, well, tribunal's entitled to reach that conclusion. It has to have proper factual basis for it. And this does not indicate the necessary level of subordination and control envisaged by Uber. So tribunal then, its analysis is at paragraph 88. Very short analysis. So the tribunal's particularly impressed by paragraphs 71 and 76 of Uber about the importance
Did you say, when did you say 88? You said?
Yes, 88.
Yeah.
That's fine, but that's not necessarily the central issue in Uber. That's simply telling you that you need to look at the reality. Then 90, it's inconceivable that Mr Lutz was wearing his Ryanair uniform and flying a Ryanair plane filled with Ryanair passengers and being paid to do so was not a work. And then conclusion there, 91, as Ryanair and MCG set up the situation, and as MCG paid Mr Lutz by a service company they set up, he was a worker for them. He was not working for a service company for the reasons given. No one says he was a worker for Ryanair. That is not the claim. So it's rather difficult because one cannot normally have two bosses. So he can't be a worker for both. And the reason why the tribunal alights on the conclusion that it's worker for MCG is because the claim is brought against MCG and not against Ryanair. That's how one would ordinarily read paragraph 91. So the tribunal has respectfully led into error, and that is not a supportable conclusion from those facts.
Well, the only factor they identify is that it's MCG who pays it.
Yeah, exactly. And that is not inconsistent, of course, with employment, but it's also not inconsistent with any other contractual arrangement which involves the transfer of money. There's always a paying party in a contract. We can deal with the EAT then, please. Judgment is at tab 11. So 146. Of the decision, which is at page 218. Now we're going to try and make some time efficiencies, if I may, but my first complaint is paragraph 146. Insofar as the EEAT says that our case was that this is impossible by reference to Uber or Allenby is simply a misunderstanding of the argument that's being advanced. The case has always been, well, it's possible, it depends on the facts. So we agree with how it's put in Roman 3 on 219. It is possible that the lecturers were workers of the agency. But I didn't say, and do not say, that Uber limits the situation or says anything different from Allenby. It's obvious that Lord Legate is applying Allenby. So that's the first objection. It appears to have just been a misunderstanding of the argument advanced. Then the fundamental question is, well, did the ET err in law? And this is addressed from paragraph 151. So 152 indicates that certainly an initial reading of the tribunal's decision suggests that there might be problems. But then the EAT is satisfied that it didn't err in law. And we say that the 6 points made in paragraph 153, but we disagree with all 6 in terms of their relevance. So 153 says, firstly, had a contract with MCG. Well, doesn't really tell you very much, if anything at all. Secondly, not in business on his own account. That is evidentially relevant, so I don't say that's wrong, but it's not a sufficient answer in itself. You've still got to deal with the positive argument, or what are the factors which point to there being a worker relationship, not just the negative factors. And then thirdly, the EAT refers to the imbalance of power and all the bargaining power with Ryanair. That doesn't tell you anything about a worker contract with MCG. Fourthly, paid. Well, that's true, but that's also in the context of Ryanair setting it up. And it is the inherent activity of making payment, which arises in all sorts of contracts. And fifthly, independence entirely notional, fine, but that's dealing with a different issue, broadly speaking. And sixthly, and the EAT said not disputed that MCG had documented obligations, but the difficulty with this, and the point I've already made, is that one has to look at the tribunal's understanding of the arrangement, not simply what is in documented obligations which don't feature at all, certainly not in any prominent sense, in the tribunal's decision. And that is particularly so when aspects of the contract are asserted as sham and found to be sham, i.e. the substitution clause.
Well, hang on. There are no obligations, are there, under the agreement with Dishforth that are found to be shams, except for substitution?
Yeah.
Precisely.
Yeah. So we say that those factors, insofar as they seek to improve or identify that the tribunal has not erred, do not themselves engage with the relevant question. Where is the EAT asking itself the pertinent question? Or where are the indicators of control, subordination, etc.? And simply identifying certain factors which, in the large part, don't even refer to my client, but otherwise don't meaningfully engage with that question, we say does not mean that the tribunal's decision can stand. So what do we say? Well, we say that those findings are essentially cogent insofar as they indicate that there is no relevant employment relationship. So there doesn't need to be remission on MCG ground 1 because the findings, properly analysed, do not support the conclusion that there is a relevant employment relationship between MCG and
Not just do not support, I'm incapable of supporting.
Yes. That's my ground 1. I'm going to take my ground 2 fairly shortly. So ground 2, EU Charter, do you somehow, on the hypothesis that we're right about ground 1, this is a relevant hypothesis with which we're concerned, that the claim has failed under the domestic legislation, is there an independent basis for an identifiable employment claim under the Charter, to which we say, well, it plainly isn't, because Article 31 does not support that. That's tab 9, so authorities. Tab 9.
Yeah.
Page 81, Article 31. Paragraph 2, every worker has the right to limitation of maximum working hours, to daily and weekly rest periods, and to an annual period of leave. Again, bear in mind where we are in the architecture of EU law. This is the Charter. The detailed prescription, the normative effect of what that actually means, has to be given expression, because it's not a prohibition or an equal pay right. This is simply a statement of a right to, relevantly here, annual period of paid leave. Doesn't say anything about 4 weeks.
So basically your submission is this is not sufficiently specific to give rise to enforceable legal rights, is that it?
Yeah, exactly. And you can't have a situation in which Mr Lutz, uniquely in the United Kingdom, is able to access some sort of prescribed annual leave right even though he doesn't qualify under the Civil Aviation Working Time Regulations, and every other person, their claim is denied because insofar as we made that concession, it never gets made again.
Well, yes, that's not quite the right target, is it? From the point of view of from an EU perspective, what matters is not so much the regs as the directive. To which you haven't taken us. But I get the broad point that it's not sufficiently specific to give leave to legal rights at all, but you were then making a distinct point about how when a right wasn't given you by the regs, how could it possibly be right that you could be given it by the Charter? But I think the EU perspective, the question, if you have a point at all, is if you're not given a right by the Directive, how could you be given it by the Charter?
Yes, assuming for these purposes that the regs and the Directive are allied and that there's no difference, we're not mar-leasing anything here. So we can approach this by reference to the regulations and the way that Lord Legate has done, and we can reach our conclusion that there is no relevant employment status on that basis. Then the sole question is, well, do you have some other EU right? Mr Lutz's answer, yes, I do. Article 34(2). You say it's not specific. Because it requires national implementation, and the authorities that's stated in our skeleton argument, so it's paragraph Max Planck. It's the Francisco Carreras-Sequeiros case.
So I didn't hear what you said.
Francisco Carreras-Sequeiros, which is at tab 43.
Oh, so is that the same as the Max Planck case?
No.
You mentioned the Max Planck case, but no, don't worry. So which is the case you wanted to go to?
The Francisco Carreras-Sequeiros.
Yeah, but where?
It's tab 43, which is
the last one.
3.
Yeah, okay. What's the nature of this case? It's not a reference. It's a commission case.
Yeah.
The staff regulation.
So it's internal. Yeah, it's an internal staff regulations case.
Oh, I see. And those go firstly to the General Court and then can come on appeal to Grand Chamber. That's what's happened here.
Yeah.
Yes, I see.
Then the point of the court, just take it from paragraph 111, which refers back to the Advocate General, and
paragraph 100. What page though?
817 in the bottom right.
So this was Advocate General Sharp's, was it?
Cockott, I think.
The Cockott, right? Have we got that? Yes, I see.
Yeah, we do have the AG.
Sorry, how much of this you asking us to read?
Sorry,
I don't
it's,
think.
it's just paragraph 800 and, paragraph 111.
Read that at 112.
Well, no, just 111. So the point is the Charter, in this respect, does not have concrete normative expression because it doesn't tell you, for example, what...
I see. That's all you're saying. That's all you need.
That's what I need. So
Can we just see where's 64 in the applicant general's opinion? I think I found it. It's page 811.
Thank you.
Oh, no,
I don't think it is, isn't that?
no.
That's the court, isn't it?
It's the preceding divider.
Proceeding
42.
tab.
Preceding tab, yes, 42.
Oh, I see. Yes.
Yeah, thank you very much. So page 790. So it's 63.
Ah,
Can I
yes.
ask-
Thank you. That looks it. Let's have a look. Yes, I'll probably need to read 65 as well.
So 62,
Yeah.
sidelined by Mr Lutz. So the point about the working directive, time directive, in the minimum 4 weeks. I just can't read it.
Sorry, I didn't hear what you just said.
62, please.
I've read, speak for myself, I've read from 62 to 65.
Yes, right. So where are we on all of this? No one is suggesting that there's some yet further employment status under the Charter. So the issue is essentially a concession type point as it's put by Mr Lutz, namely that our position has been, well, it has to be working time regulations, either CAWTR or nothing, for this claim to succeed, because that is the concrete normative expression of the actual claim, which is the right to annual leave. That's how the claim, that's certainly the bulk of the argument in the tribunal. And the point is made, well, actually you should have appealed the finding, which was a consequential finding, essentially, that he's also a worker under the Charter, to which we say, by reference to this point, well, it doesn't make any difference, because if you failed under the domestic provisions and the directive for these purposes, you can't come in through the back door of the Charter, that's what it comes down to. They say, no, we can, because you can read into the Charter, I suspect what is going to be said, a 4-week minimum, or alternatively, the tribunal is going to have to fashion it. And we say, well, you can't read it in. And if that is right, then it does follow that concession should not have been made, and we should then have maintained the point that for all relevant purposes, Mr Lutz is not a worker. That's how we...
But is this really your point? Forget the regulations, but just think about the directive. If you're not entitled under the directive,
Yeah,
you can't be entitled under the Charter. That would be bizarre.
that would be bizarre.
Yeah.
And there would only be one person, namely the respondent in the world, who would have that benefit, and it would arise because of what is said to be the fact that we didn't appeal it under from the tribunal. Because otherwise there'd be a finding, effectively, that there is no relevant accommodation.
But I really obviously I missed all this in the skeletons. Is it really being suggested that because this point wasn't appealed from the EAT, you can't now raise it here?
No, it's because
Since you can raise a new point in a court of appeal, you can certainly raise a point that you failed to. You may need our permission, but
well, is it being said that we can't? I don't believe so, and
So-
the lady's given us permission to run it.
So what's all this point about him being in a unique position? Simply because of a procedural step taken in the action?
Perhaps I'm better off dealing with it in reply. So
Why not deal with it in reply? At the moment, in case this helps, I'm not sure how much there really is in the Article 31 point, but if there is anything in it, I can't see why you aren't entitled to take it.
my lord.
Well, they aren't entitled. I mean, why you aren't entitled to oppose it.
Yeah, well, that's how we put it.
Yeah.
Ground 3, we say, is a necessary consequence of ground 1, that there has to be a relevant employment.
Yes, now can you just help me? I got into a muddle with this with the studs. I couldn't really quite see what round 3 was about, but it made me see I wasn't concentrating enough. Can we?
Well, if one goes to the agency worker regulation.
Well, can we go to round 3 first, please?
Yes.
Sorry if everyone else understood it.
Page 50. So the grounds are at tab 1
Yes.
in the format which is encouraged, i.e.
Yes, I've got them.
Then the elucidation of it is in the skeleton.
Page 30.
Thank you. Page 30.
But sorry, am I getting in a muddle? Round 3 seems to be about the agency workers regulation.
Yeah, because if one looks at the agency worker regulations, then
Sorry, this is what you were trying to do, and I was being too short. Yeah, right. But just explain it to me in ordinary, assuming I haven't understood it at all, which I haven't.
yes, it's much easier to do it with the legislation in front of.
Okay, right.
It's tab 6, please.
Yep.
So we say that the reference to the contract there must be to a contract in the relevant sense, i.e. a worker contract.
Which?
So 3.1a.
3.1a.
If there is no finding of a worker contract,
Sorry, there isn't a reference to a contract in 3.1a.
so an agent supply, yeah, so 3.1a and b.
And B, right, yes. Yeah.
So if the outcome is, partly because of the way the case has been argued, but if there is no relevant finding of a contract, then that applies also to the Regulation 3 definition of an agency worker. If we're right on ground 1 and there's no other relevant employment contract, then outside scope by reference to the definition in 3.1a. That's the start and the end of it.
Oh, I see. Sorry, so this is not at all about the claim only against you. This is about the claim for equality of terms.
Yeah.
Oh, I see. Sorry. Right. Because yeah, okay. Okay, yep.
Okay, on to ground 4. So there's one point I'm dealing with. And because the court has it open, if you could stay, please, with Regulation 3. So, agency worker means an individual who, A, is supplied by a temporary work agency to work temporarily for and under the supervision and direction of a hirer. A, and B, has a contract with the temporary work agency, which is ... So we say that 3.1a concerns the supply of the worker from the temporary work agency to the hirer. So the relationship that one is concerned with here is the relationship between MCG and Ryanair. B is looking at the contract between the agency and the individual, which can be permanent or temporary. And for that purpose, because of the anti-avoidance provisions, you take into account all the intermediary companies. And
Sorry, you're going too fast for me.
yeah, sorry.
Right, what you're talking about the anti-avoidance provisions?
Don't need to be concerned about them. What matters here, Mr Bowers is going to tell you what temporary means. What I am focusing on is which supply are we looking at when considering the temporary question. And it is my submission that we are looking at 3.1a. We are looking at the supply from the agency to the hirer. And one has to decide whether it is that relationship which is temporary or not. Not the 3.1b situation, which can be temporary or permanent. The point here is that if the worker, Mr Lutz, is not supplied temporarily from MCG to Ryanair, then the regulations do not apply.
How does that help you on the facts of this case?
Okay,
right.
So what you need to do, though, what the tribunal failed to do, this is a remission point, because it simply just failed to deal with this. It needs to look at the nature of the supply from MCG to Ryanair. And that
Can't we do that on the facts that we've got?
We can't. I'll make good that point.
Okay.
Well, I'll address the tribunal judgment in a moment, but Ancarad is the authority which deals with this in terms. Well, sorry, Angard.
Okay.
So if I can ask you please to look at Angard, so tab 41, which is in bundle 3.
Yes.
Now, Mr Bowers is going to take you to this for the related purpose, but for my purpose then, if I can ask the court to look at paragraph 10, which records the tribunal at 34, correctly identifying...
Sorry, wait a moment. So this is page 761.
Yes.
Which has huge chunks of the tribunal's reasoning.
Yeah, so but just the first paragraph, please.
Yeah.
The 80 says, don't get confused between the contract between the agency and the worker. Look at the arrangement between the agency and the hirer. And the judge repeats this then at 45, 46, 54 and 63.
So 45, I won't look at it, just flag it up.
Yeah, so the...
Oh, wait a minute, which judge? Judge Auerbach?
Yeah, so the appellate judge, Judge Auerbach, repeats it at 45.
Well, the moment he hasn't set out anything, he's just he's not repeating. He's just set out what the ET said.
Yep.
So he hasn't said anything about it.
No.
Right. Okay.
The tribunal's right on this point. So the 45. The natural meaning of the words of Regulation 3.1a is that it directs attention to the basis on which the worker is actually placed, designated, directed, or sent to go and do work for a hirer on one or more specific occasions. That's what you're looking at. 46. The focus of the tribunal's inquiry should therefore be on the basis on which the worker is supplied to work on each such occasion, to ascertain plan guidance and memorandum, whether that supply is made on the basis having worked, it will continue. then picking it up again, please. There's a lot here, but if I may just highlight those which are relevant for my purposes. There's 54, which is at 771. It makes a point about, well, be careful with the documents. They're part of it's what's described as the evidential contribution. So the documents are part of the evidential mosaic, but one has to actually look at the substance of the supply.
'53 is read that, yep.
Yeah.
Where now?
Have you read, please, 58?
58.
Yeah, 58, 59 and 63.
Yes, you really need to understand it to look at the last sentence of 57. Very well.
So the short proposition, which we say should be uncontroversial but is not, is that you simply then look at the nature of the supply as between agency and the hirer, and you ask yourself, is that temporary or permanent? And the tribunal erred in focusing on the district contract, because that's not the relevant contract insofar as the contract is part of the evidential mosaic. What it needed to do was properly understand whether MCG was supplying Ryanair on a permanent basis.
Isn't it clear from the contract between MCG and Ryanair that they were not supplying them on a permanent basis?
So the findings then, Tribunal tab 18, page 273.
Just make a note. Is your submission, I just want to make sure I write it down, the Ditchford contract was irrelevant or merely not decisive?
Everything's relevant because the evidential mosaic can certainly include the contract as between the agency and the individual. So that could be a relevant indicator, but certainly not determinative.
Yes, I see.
Yeah. What is likely to be more relevant is the arrangements as between, and certainly the contractual arrangements as between Ryanair and MCG. That's the relevant supply. So that's dealt with in paragraph 27.
Paragraph 27 of the ET.
Of the ET.
What page of the bundle?
273, tab 18. The broadly speaking, the conclusion is that there's an agreement which originated in December 2011 and has effectively carried on. And insofar as those are the findings regarding the correct supply, i.e. as between MCG and Ryanair, then they are only consistent with it being ongoing. Can't be said to be temporary. If in fact it was for a fixed term period, but that expired years ago and they've just carried on.
So are you saying that at any time up to the 28th of December 2016, it would have been temporary, the supplies would have been temporary?
The danger there would be to assume that the contract is for all purposes authoritative. That's a likely situation, but there may be evidence, the perception of the parties might have been to the effect that. True it is, there is an expiry provision, but there's a very clear representation.
In fact, the expiry of the MCG contract is really irrelevant, isn't it? The question is what the MCG contract provides for or envisages about the nature of the supplies made under it. The fact that the agreement itself may come to an end and then doesn't, and is now presumably terminated on reasonable notice, is really neither here nor there.
Yes, well, one might think that if the case is being heard on the 28th of December 2011, then the contract is likely to provide a strong steer towards temporariness without, in any sense, trespassing on any other arguments that might be made about that. That's the factual position as it might have stood at the outset. What then has happened is that 12 years later, that contract hasn't actually expired in accordance with its 5-year period. There's been an ongoing supply, and whether that is contractual, and it must be contractual, doesn't really matter.
It's not an ongoing supply, ongoing obligation to supply as required.
Well, it's no, the actual, what we're looking at is there a supply as opposed to an obligation? There may have been a breach, a termination or something of that nature. And that's not likely to tell you very much about the statutory position in the agency worker regulations. So one has to look at what's actually happening. What is happening is that MCG are supplying on an ongoing basis, and the originating contract has long since expired.
Yes, but what I'm trying to just work out is the originating contract hasn't, in a sense, expired because you say it's rolled over or carried on. But and I can see in deciding the nature of the supplies made under it, whether they're temporary or permanent, the duration of the overall contract would be a relevant consideration. But it's not a determinative consideration. One's actually got to look at, if you're, as far as you're looking at the contract at all, what they undertook to do. If there was a term to say, we will provide people, but they will never work more than but they will always be on a time-limited basis for a year at a time, or 6 months at a time, or indeed 5 years at a time. That would be a clear indication that, assuming the ET was assuming Moran is right, that this was to supply people on a temporary basis.
Yeah.
So I'd quite like just to be shown what the obligation was said to be. Maybe it's unclear, but I'd like to see it, what you're saying.
This is why I did indicate that my submission is that we're in the territory of remission, because the way that the tribunal has approached this is to record in paragraph 29 what the position was in relation to MCG and Ryanair. What it then thought to be of particular significance was the MCG Dishford contract.
Yes.
So if you see
I'm assuming you're right about that.
Yeah.
But I'm asking, you've got to assume that you've got to contemplate that we might not want to remit and think that we can do it on what we've got.
Yeah.
And one of the things we've got, which you haven't taken us to yet, is the MCG contract. And I was just inviting you to show us what the MCG contract says about the supplies that will be made under it.
Yes. So that's supplemental.
Yeah, I've got behind tab 10.
Yeah.
You don't have to do this exercise, but if you don't do it, you may find other people doing it, then you're too late.
I noted mine. So,
Page 45.
yeah, 45. Then, so 46. So, commencement date, clause 2, 20th of December. Contract for services for a period of 5 years ending on 20th of December 2016. Supply arranges to arrange for services of service companies. Indemnities, taxation, termination. Broadly speaking, there's nothing in the nature that the court hypothesising a moment ago. Is there some sort of specific, well, we will make sure that each individual is only employed for 12 months at a time? Nothing of that nature.
No, but there are some, I mean, for example, the final sentence of 4, to cover these requirements, the supplier will maintain basically 4 is more like a recital.
Yeah.
And the first bits of it says our demands for pilots vary during the year. And to cover these requirements, supplier will maintain a pool of pilots to support the contraction and expansion of the Ryanair operation at short notice. That tends to suggest that these supplies would be temporary in the sense that they would be for short fixed terms to cover point where the concertina goes out rather than in.
Well, not for me to speak. So that's a tenuous basis for saying.
Maybe I'm just since you're not making submissions. I'm just. Okay, you say it doesn't go very far.
It doesn't go very far. What really matters is to look at what's actually happening. I.e., you've got a contract. It's the same contract, and there is, as the other findings which I showed you under round 1. Tend to suggest that you have a very high degree of integration on an ongoing basis into the pool of employed pilots.
The integration, really the only unit we're looking at is a rostering period, whatever it is, 2 weeks, 4 weeks. Well,
yeah.
A rostering schedule.
Yes.
And there may well be a high degree of integration then.
Yeah.
But what if beyond the programme that's rostered for, they decide they won't need fewer people, so they won't have all your contracted pilots?
Yes. But there is nothing to that effect in the decision. I see that it is possible that in this arrangement it could be temporary. The error is the simple one that the tribunal seems to have thought that the 5-year duration of the Dishworth contract answered that question. One sees that at 102. It's simply looking at the wrong place.
Now, for what it's worth, I don't know where this goes, but actually the MCG agreement isn't for 5. Well, it is for 5 years, but it's terminable by either party on 3 months' notice.
Yeah.
Well, I don't know who that helps or not. Nobody seems to focus on it, and maybe it's irrelevant. But clause 18 appears to say that.
Yes. What we would say, consistently with general submissions, is that contracts are obviously helpful for the reason indicated, namely that they indicate what the parties are normally doing. But in circumstances where they're not, and this is an example of where they're not, then it might be that their value is a bit more limited. So it's simply, insofar as it addresses the matter of paragraph 27, that is consistent with, in fact, this not being temporary. It's an ongoing supply. But in fact, it was just looking at the wrong kind of contract anyway.
Right, well, now, don't have to stop there, but
Go on.
maybe that by extremely elegant timing, you've reached the end of your submissions as predicted.
Yes, I might just reserve the right to something, but I don't think we're going to. So it will be Mr. Bowers after the shorter judgment.
Thank you very much. Well, we're sitting at 2.
Court rise.